Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at Ballard Spahr. And I'm your host, Alan Kaplinsky, the founder and former practice group leader for 25 years, and now Senior Counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm very pleased to be moderating today's program. For those of you who want even more information, either about the topic that we're going to be covering today, which I'll introduce in a moment, or for that matter, anything else in the world of consumer finance, don't forget about our blog, which goes by the same name as our podcast show, Consumer Finance Monitor. We've hosted the blog since July of 2011, when the CFPB became operational. There is a lot of relevant content there for sure. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspar.com. And if you like our podcast, you please let us know about it. You can leave us a review on whatever platform you use to access this podcast. And please let us know if you have any ideas for other topics that we should consider covering or speakers we should consider inviting as guests on our podcast show. So let me tell our audience what we're going to be talking about today. We're going to be revisiting a topic that we explored several months ago, it was last year to be precise, when the CFPB first proposed sweeping changes to fair lending enforcement under the Equal Credit Opportunity Act, which from now on, I think most of us will refer to it as ECOA. At that time, we discussed what many viewed as a potentially transformative proposal, one that would eliminate the long-standing use of disparate impact analysis and significantly narrow the scope of discouragement liability under Regulation B. Now, the CFPB, under Acting Director Russell Vogt, has finalized that rule, and notably, he has done so largely as it was proposed last year. As reflected in the final rule, the Bureau has done the following three major things: eliminated the use of disparate impact analysis as a tool for identifying discrimination under ECOA. Second, narrowed the scope of discouragement liability rather than broader conduct, focusing more squarely on spoken or written words, including visual images rather than broader conduct. And it's also revised provisions concerning special purpose credit programs, particularly those offered by for-profit entities. The Bureau's position is that ECOA does not authorize disparate impact liability and that enforcement should be grounded in clear statutory authority and evidence of intentional discrimination rather than statistical disparities alone. This is a very significant shift. For decades, regulators have relied on statistical analysis to identify patterns of unintentional discrimination. The final rule marks a clear departure from that approach and aligns with a much broader policy objective of emphasizing statutory text and limiting regulatory overreach. Supporters argue that the rule provides greater clarity for lenders, more predictable compliance obligations, and a framework better suited to innovation, including AI-driven underwriting. Critics, however, and there are many, we'll hear about that today, argue that removing disparate impact as an enforcement tool can make it more difficult to detect systemic discrimination, particularly where bias is embedded in algorithms or what are facially seen to be neutral policies. So today, we're going to unpack what this final rule actually does, how it differs from prior practice, the prior rule. I'm not talking about the proposed rule, but the prior rule, and what it means for banks, fintechs, and the broader consumers, and for the broader consumer finance market. I'm joined today by three terrific guests, all of them exceedingly well qualified to discuss this topic today. And first, our very special guest, Brad Lauer, who is the principal and founder of Inclusive Partners LLC. Brad brings a unique perspective on fair lending, compliance, and inclusion, and has been deeply engaged in how institutions operationalize these requirements. So, Brad, it was good having you on this webinar that we did last year for the proposed reg. And we're delighted to have you back to talk about the final version.
Thanks, Alan, for having me back. Appreciate it.
Yeah. And next, my colleague, John Culhane, who has written and spoken extensively on CFPB rulemaking and in particular Regulation B developments. And also my colleague, Richard Andreano, a leading authority on fair lending and mortgage regulatory matters, who has very closely followed both the proposal and the final rule. So, Brad, John, Rich, welcome back to the podcast. So, I have a lot of questions for each of you, but I'm inviting anybody who wants to chime in on a particular question that I'm not directing to that person. Feel free to chime in, because we want to have a very interactive discussion on this extremely important topic. So we're going to start with you, Brad, as our honored guest, and we're going to call this Setting the Stage. When we last spoke about the proposal, we highlighted how significant a departure it was. Did anything in this final rule surprise you, or is this essentially what you expected? And I said I was going to go to Brad. I'm going to go to Rich on that one.
Yes, thank you, Alan. A good day, everyone. I thought they would adopt what they proposed, and that is what they did. And here are the reasons for that. On the disparate impact item, and disparate impact, of course, is unintentional discrimination. Early last year, the Trump administration issued an executive order indicating that it was the policy of the federal government not to pursue disparate impact liability. So it was pretty clear that the proposal to remove the disparate impact, which then the effects test language from Reg B, was something they were going to adopt. Second, on the discouragement provisions, and we'll get into this a little deeper later on. To me, I'm calling it the Townstone Financial Rule. That was the redlining case that the Bureau had brought against a non-bank mortgage lender in the Chicago area. And the current CFPB leadership is very much opposed to how the prior leadership went after statements by Townstone, viewing them as discouraging applicants or prospective applicants. So I thought they would adopt those discouragement provisions to narrow what's considered discouragement. And third, with the for-profit special purpose credit programs, limiting those is consistent with this administration's opposition to DEI efforts and anything that offers race-based preferences.
So, Brad, at a high level, how would you describe the most consequential change in the final rule from the prior rule, or the Reg B as it existed before the proposal was made?
Yeah, I think the biggest change, they're all three of the sections you described are huge changes. But I think the biggest change is the Bureau's complete refusal to acknowledge the history of discrimination in the U.S. and the congressional intent of addressing that discrimination and continuing inequalities through ECOA. And so that resonates through each of these sections of, eliminating disparate impact as a tool, very narrowing the ability to bring discouragement claims, and narrowing also the ability to do special purpose credit programs. It's all part of kind of a dogmatic approach at the Bureau to really root out any kind of acknowledgement that there's been a history of discrimination in the United States, and acknowledging congressional discussion, but basically disregarding it and saying we're just going to look to the language of the statute. That's the biggest change.
All right. Well, let's start with disparate impact. We're going to cover the three major changes that you identified. And my question is going to go to John, but then I would like to hear Rich chime in on the mortgage impact, or how you would answer it as a mortgage attorney. The CFPB's now definitively eliminated disparate impact as a tool under ECOA. How big of a shift is this in practical terms, and does the type of credit matter? So, John, we'll start with you and then go to Rich.
Well, it's a dramatic shift in federal law at least for non-mortgage credit. There have traditionally been three types of discrimination: overt discrimination, disparate treatment, and disparate impact. And outside of the redlining context, where claims have always been that the conduct amounted to both disparate treatment and had a disparate impact, we really don't see much in the way of overt discrimination cases or disparate treatment cases. It's all been disparate impact. Now, I don't know if the CFPB has definitively eliminated it. I guess we'll find out as the litigation unfolds. And certainly, to the extent it has been eliminated, it's only been eliminated at the federal level. But two, maybe three immediate impacts stood out for me. One is the impact on indirect auto finance. The CFPB and the FTC and the Department of Justice have had a history of using disparate impact to assert that dealer markup pricing has a discriminatory impact, and there have been numerous cases that have been brought on that basis. The CFPB and federal banking regulators in the student loan context have asserted that the use of the cohort default rate or any criteria based on the nature of the school that a student is attending may have a disparate impact, and that's had a dramatic impact on private student loan programs. And then the other one that sort of jumps off the table at me is what looks like it will be a maybe crippling impact on the ability of women to assert a disparate impact with business credit, particularly coupled with developments with the Section 1071 rule, which I'm sure will be a subject of a webinar or podcast or maybe both.
Okay. So, Rich, John painted a pretty impactful, he basically said that this change in the non-mortgage area is extremely impactful. Not so much in the mortgage area, right?
Yeah, much less. I agree it's a sea change in the non-mortgage industry, but the mortgage industry is covered by both the ECOA and the Fair Housing Act. Now, in its 2015 ruling in the case Texas Department of Housing and Community Affairs versus Inclusive Communities Project, the Supreme Court held that disparate impact claims may in fact be brought under the Act. Now, it was as close as a decision you can get, 5-4. Former Justice Kennedy wrote for the majority. He was joined by current Justices Sotomayor and Kagan and former Justices Ginsburg and Breyer. Obviously, the court's changed a lot since then, and that may be an issue in the future. But for now, the decision remains the law of the land. So mortgage lenders and other parties covered by the Act, such as real estate brokers, appraisers, title companies, and such, remain subject to federal disparate impact liability. There is some differences, though. One is the Bureau will not pursue the claims now. The only ones who would in the government would be HUD and Justice Department, but also their private right of actions under the Fair Housing Act. Now, this administration has indicated it will not pursue theories of disparate impact liability, but no administration lasts forever. Another difference, and this is significant, is the Fair Housing Act has much shorter statutes of limitations, generally 1 to 2 years, depending on who's bringing the claim and the situation, whereas ECOA has a 5-year statute of limitations. So that is a significant difference, that the liability of the mortgage industry has now been reduced in terms of years.
How about the penalties, Rich, under ECOA versus fair housing? Are they similar?
I've generally found that when these cases have been brought, the penalty differences don't come into play as much, that ultimately the parties reach a settlement and just decide on a number that both parties agree to. So there, I don't think it will make a difference. One key, though, is if you recover under one of the acts for a claim, you cannot also recover under the second act. So there's no double penalties. But usually they don't rely on the penalty provisions of the acts. They just come up to a number. And nowadays, it's more what we saw the Bureau switching to and other regulators switching to was remediation to consumers rather than penalties to the government.
Yeah. I have one other question for you related to what you said, and that is HUD. HUD has right now a regulation on its books, am I right, in which it tries to implement the Supreme Court opinion that you reference, and inclusive communities, I think is the name of the case. And as I recall, they are trying to eliminate that regulation. I think they've issued I think it was maybe an advance notice of proposed rulemaking, or maybe it's actually a proposed reg to wipe that out, right?
It's actually a proposed rule. Yeah, they actually adopted this before inclusive communities, where there were 2 cases that came before the court, and during the Obama administration, and the Obama administration was concerned how the court would rule, with good reason. It was 5-4, so they were concerned it could have gone the other way. Those cases settled, but before those cases were brought, HUD did adopt a disparate impact rule. Purportedly, its hope was that under what was then the Chevron doctrine, which has since been rescinded by the Supreme Court, the Supreme Court would defer to HUD. The Supreme Court did not defer to HUD. It acknowledged the existence of the rule, but it ruled on what it thought was the merits of the statute without regard to the rule. We were interested, now that, however, the government had announced its position that it would not pursue disparate impact liability, what would it do with the HUD rule? We understood they were reconsidering the rule, and the reconsideration is eliminate the rule. And the theory of that is disparate impact liability is liability that should be interpreted solely by the courts and not by HUD.
Okay, so it's not, I mean, I guess what it means, cutting through it, it's very unlikely you're going to see HUD bring any disparate impact cases because they're part of the administration, right?
Right. And yes. And in particular, the Office of Fair Housing has been pretty much dismantled at HUD.
Right. But private litigation is brought. I take it the private litigator will be able to rely on inclusive communities and
exactly.
The statute, right?
Yes. Yeah, I think what will be different is sometimes community groups would file administrative claims under the Fair Housing Act with HUD. Given that the office has been pretty much dismantled, that's probably not going to be a good path. I think now the path they would have to do is go into federal court.
Yeah. Well, thank you, Rich. So, it's as a lawyer who focuses a lot of your practice in the mortgage area, you're basically, it's business as usual, right?
Stay the course. Stay the course.
Comply. So, Brad, I want to go to you, and then I want to go to Rich, and that is, as we've stated before, regulators relied on statistical disparities to bring cases. What does enforcement look like now if that tool is off the table, both for the CFPB and it's off the table for HUD? What do we expect to see anything? And all of you said, I don't think you've seen too many cases involving intentional discrimination. Is this the end of fair lending as we know it?
Absolutely not. And I would just question a little bit the premise that it's off the table because the states, certainly their state laws where states can bring disparate impact claims, private plaintiffs can bring under federal law disparate impact claims. Even the Bureau in its commentary on the disparate impact provision said, I guess commentators were in the industry were saying, why don't we just, you provide guidance that you can't get any kind of recovery for disparate impact in the courts. And the Bureau acknowledged, like, this is a rule, a reg. We have limited authority. The courts have the ultimate say on what you can recover and what theories you can recover under. So you can still bring a claim for disparate impact in federal court. It's just you're not going to see a federal regulator.
A private claim.
Private claim, absolutely.
Yeah.
So what I think you're going to see in enforcement and private cases and state cases, and we're already starting to see this even under the Biden administration, is we're not going to see cases foot faulting a creditor for some minor disparities, but where there are significant, substantial differences in the applicants based upon race or ethnicity or gender or any of the protected classes, significant disparities that are like 2 or 3 times the difference greater than their peers in the market, right? Comparing lenders. You're seeing those kind of disparities, and you're seeing any kind of language in the policies, or you're seeing emails. You're starting to see disparate impact cases brought really as disparate treatment cases. The statistics are being pulled in to a disparate treatment case. So I think that's going to be safer ground, and I think that's what you're going to be seeing in the next couple of years under this administration, those kinds of cases.
Yeah. Rich, what do you think?
Similar thoughts. Now, the Trump administration has made various statements saying that disparate impact claims were based solely on statistical analyses and criticizing that. But what I really have observed, particularly in the mortgage industry, different. Now, of course, in the mortgage industry, we have the Home Mortgage Disclosure Act, and the CFPB would examine the data under that act to identify lenders who they thought deserved a closer look. But they didn't immediately say, aha, we're concluding conclusively that this lender has violated ECOA. They just say, we think based on the statistics, we need to take a closer look at this lender. They would ask for additional statistics that are not in HMDA to further do analysis to see if that perhaps eliminated the disparities. But they'd also look at the conduct of the lender. Where did they advertise? Where did they place their offices, particularly in various metro areas? Were any offices in majority-minority areas? How many applications did they receive from majority-minority areas? How many loans did they make in majority-minority areas? And they would add that evidence to the statistics to then determine that they think there was a violation of ECOA, but as Brad said, under both a disparate impact claim and a disparate treatment claim. So, I still think also, since we have the Fair Housing Act, we have disparate impact claims there, but really those claims aren't based solely on statistics. The statistics help identify the lender and help support, and what they do in the end, look at the conduct you engaged in intentionally, and the statistics show the result of that conduct.
And I would add here, any credible lender that's out there is still going to be looking at their lending patterns to see if there are disparities. It's a great diagnostic tool. And if a lender sees that it really is out of step with its peers in the market, it's going to try to make corrections. So, I don't think you're going to see a retreat from the market of those kinds of compliance efforts.
Yeah. So you referred, I guess it was Brad, you referred to the fact that there are states that, are largely unaffected by what the CFPB has done here. Some of them have their own anti-discrimination laws. Some of them basically mimic ECOA. And while I think everybody has concluded that we're not going to see much enforcement going on at the federal level, there are states that are just going to simply say the CFPB regulation is wrong and we're not going to follow it. I think Massachusetts fits into that category. Am I right?
Yeah, I've been surprised that there haven't been more cases, but you're right. Massachusetts is one of the many states that I would put in the category of ramping up, not only using their own staff, but they've actually entered into contracts with private law firms who specialize in fair lending enforcement and civil rights cases to work with them on developing cases. And one of the first settlements out of the stocks was called the Ernest case in Massachusetts, and that was a student lending case where the Massachusetts Attorney General alleged that Earnest wasn't monitoring its student lending models for disparate impact. And it also, Earnest was using data that was highly correlative with race and ethnicity, like your immigration status and what school you went to in their models. And so the AG kind of went to town on them and said, look, you're not even doing basic compliance on your models, but monitoring your models, and you're using data that's a proxy for race and ethnicity. So I think you're going to see more of those cases, and those are disparate treatment cases and disparate impact cases. But I have been surprised there haven't been more announced cases to date.
One of the interesting things about the Earnest case is the Massachusetts AG went out of her way to say that disparate impact was a theory of liability under the Federal Equal Credit Opportunity Act, notwithstanding any noise that might be going on at the CFPB. Although that last part wasn't said out loud, but it was certainly telegraphed in the settlement.
It's almost like we're acknowledging that the federal cop's not on the beat anymore, and so we're going to be the cop on the beat now as the states.
Right. So, John, there are some states that by state statute or regulation still apply disparate impact. I mean, I recall that New Jersey amended its regulations under, I think it's called the Law Against Discrimination statute, and that was done, I think, either toward the end of last year.
End of December,
Yeah, when Matt Placken, who was on one of our webinar shows when he was Attorney General of New Jersey, when he was still in office. Do you expect that there are going to be efforts made by other states to enact legislation that is similar to what New Jersey has done, or to adopt regs?
Yeah, yes, I do think that there will be efforts like that. But I think what we're going to see two things. One, there are a number of states that have previously taken action and asserted that a variety of laws prohibit disparate impact. One example, the New York DFS sent a letter to the financial institutions it regulates just a couple of weeks ago, advising financial institutions in New York that the DFS considers disparate impact to be part of to be a viable and enforceable theory under New York fair lending law, and basically putting everyone on notice that they'll be proceeding. In the past, we've had various states use fair lending type laws, public accommodation laws. Massachusetts has used the Consumer Protection Act. I forget if it was Arizona, I think, has even asserted disparate impact claims under the Consumer Fraud Act, and the Arizona Consumer Fraud Act, in actions against automobile dealers. So I think we're going to see that kind of creativity, flexibility from a number of states. And then I think we're going to see a host of states and state regulators imitate New Jersey and adopt laws or issue regulations, including disparate impact as a theory of liability. It was kind of interesting at the same time. New Jersey issued its rule. New York enacted a law in the employment context, not in the credit context, but expressly making disparate impact a viable theory for discrimination in employment. I think we're just going to see that continue all across the states.
Okay, let's move on to the discouragement. And, as we've mentioned, it narrows liability for discouraging somebody to apply for a loan. Focusing on oral or written statements, spoken or written words, including visual images, rather than broader conduct, such as a decision about where to locate branches, where to advertise, and where to engage with the community through open houses or similar events. How meaningful is that change, Brad? And then I'm going to turn to Rich to get the mortgage perspective.
No, it's very meaningful. And as Rich mentioned at the beginning of our discussion, the Bureau basically ignored the Seventh Circuit's decision in Townstone Finance and said, which that decision said, yes, your actions as a lender the kinds of statements you make on a radio program, your policies and procedures, where you look at your branches, things like that, are discouragement. They can be discouragement. And the Bureau purports to say, no, your conduct really doesn't matter. You have to have basically overt, blatant discrimination, either in a written or oral statement, a sign saying, blacks need not apply, a statement directly to someone's face saying, don't enter my building and apply for the loan. And that's really not the language of ECOA or the purpose of ECOA at all. It's meant to cover discouragement. So I don't think you'll see some lenders that may defend themselves and say, oh, when we located our branches and only in affluent white neighborhoods, and we sent loan officers to those areas, and we advertised in only those communities, we weren't discouraging. We were just, as the CFPB said, triaging our resources. I don't think that's going to be a legitimate defense that's recognized in the courts. They're going to look to that conduct, and they're going to look to see whether it's a pattern in practice that triggers redlining concerns. And we also have to think about the other statutes that haven't changed: the Community Reinvestment Act, the Fair Housing Act. I mean, if you're not lending and doing investments in your community, you're not only trashing your reputation with state regulators and your communities for discrimination, but you're not going to get a very good Community Reinvestment Act rating by your federal regulators. So these are other statutes that come into play in the discouragement aspect of this. Your conduct does matter.
Let's not forget that the CRA regulators are also a part of the Trump administration. Right, so
they are, but and now we're back to this 1995 rule. But the 1995 rule does still look at where you invest in, where you lend in your community, where you do business.
Right. Okay. Thanks, Brad. Rich?
Yeah, as I noted earlier, I think the discouragement provisions were triggered by the Townstone financial case. And again, this was a redlining case, first one ever brought against a non-bank mortgage company, Townstone Financial, which is a small company in the Chicago area, and asserting that they engaged in redlining in violation of ECOA. And it had your typical redlining complaint based on statistics and other factors such as where offices were located, applications received, loans made, but it had a unique aspect, which is probably what brought the Bureau to file the suit. But again, it was filed during the first Trump administration. The principals of Townstone had a radio show and podcast in which they made statements from time to time regarding African Americans and African American neighborhoods in Chicago that the prior Bureau viewed as discouraging African Americans and members of these neighborhoods from seeking credit from Townstone. And I'll give you some of the examples of the statement. In these areas, there was a grocery store that's part of the Jewel Osco chain, and they referred to it as, quote, the jungle jewel, close quote, and a, quote, scary place, close quote. They also stated the south side of Chicago between Friday and Monday is, quote, hoodlum weekend, close quote, and that the police, quote, are the only ones being between that turning into a real war zone and keeping it where it's kind of at, close quote. And then they had a loan officer on it discussing a skydiving experience and the rush you get from skydiving. And one of the principals says, well, you can get the same rush, quote, walking through the south side at 3 a.m., close quote. Ultimately, the matter resulted in a settlement after the Seventh Circuit decision that the redlining claim could be brought and discouragement was valid provisions in ECOA, settled in November 2024, but entered the Trump administration in March 2025. Rather than trying to terminate the consent order early, and a lot of fair lending consent orders have been terminated early by the Trump administration, they sought to have it completely vacated. And at the time, Acting Director Russ Vought made some strongly worded statements against the prior leadership, but particularly on the discouragement area, CFPB senior advisor Dan Bishop said, quote, this was a flagrant misuse of government resources to destroy a small business that did nothing wrong, close quote. And then in particular, quote, for the crime of protected political speech, this firm was targeted and harassed for years by this rogue agency. We were righting the wrong and protecting the First Amendment, close quote. So I think, in fact, that it was that case that encouraged the Bureau to revisit the discouragement provisions. Now, the court declined that request to vacate the settlement, but this is how I think Bureau is now trying to address some of those discouragement statements. Interesting, however, I'm not sure what they did actually would immunize these statements from claims of discouragement, because they were more going to acts like where you put an office, where you advertise, things like that. These were pretty direct statements at neighborhoods that were majority minority neighborhoods. So, yeah.
The one thing I'm wondering about in that regard is what to make of the knew or should have known standard, because a lot of the arguments that Townstone made were essentially this was really a minuscule amount of the radio time. And didn't they also, I think, present a survey of prospective customers?
Exactly. They played the entire radio shows and podcasts. They engaged a consultant that had done some work from the Bureau to play the entire radio shows and podcasts to African Americans. And their interpretation of the entire recordings was they did not have a negative view of Townstone. And it is interesting there how that will be.
Yeah, I think that's another way they went after Townstone was with the knew or should have known standard, that that sort of level of conduct didn't rise to the should have known.
Should have known. Yep.
But I think one important point here too is that you had these arguments made by the Bureau in appealing Townstone or in responding to the appeal of the district court decision in Townstone, and you had the Bureau's attempt to vacate the settlement, and federal court stepped in. Even the original court that made the terrible ruling in Townstone stepped in and said, no, we're going to honor a final settlement. And the Seventh Circuit saying, we're going to look to all this conduct in its bits and pieces. It's not, and not just the radio show, but the low level of applications that were coming into Townstone and the low number of loans that the institution made. And as we were discussing before, it's not just statistics. It's looking at all of these indicia of discrimination together. I think the courts are still going to be not turn a kind eye on institutions.
I think what I think though is that the CFPB has tried to give courts that want an opportunity to disagree 2 outs. The looking at the nature of the speech and declaring it to be protected by the First Amendment, and then looking at the volume of the activity and asserting that it doesn't rise to the level of known or should have known, or that survey information is enough to rebut that kind of a claim.
I know it's interesting. In the discouragement area, the questions I typically receive were a little different. It was when a lender had been analyzing its statistics for where it was lending, where it was getting applications, and realized in particular communities it wasn't getting applications perhaps from certain groups like Hispanics or such, and wanted to address that by engaging in affirmative marketing, and wanted to make sure that by specifically targeting Hispanics to become applicants, that they weren't somehow discouraging other people. There was prior commentary language that in fact indicated that was not the case. That was removed, but they said they removed it because they put similar language in different provisions of the commentary indicating that affirmative marketing to one group is not discouraging another group. So I think we're still pretty careful there. I still think you have to do it with care. Keep your marketing to other groups that you have been getting applications from. Just supplement it with additional marketing to try to get more applications from the group that you've been underserving.
We talked a little bit earlier. We've mentioned that even though they've made all these changes with disparate impact and discouragement, that seem to be the view of all three of you, that it doesn't really change compliance responsibilities. It may has an effect on who might sue you, how they can prove a case against you. But in terms of being practical here, I think that's really what our audience wants to hear. Is it really business as usual? Should banks and other non-banks that are engaged in lending, both non-mortgage lending and mortgage lending, just continue to do what they've always done and to test for disparate impact and to see whether under the old rules that somebody could claim that they were engaged in unlawful behavior? So let me Let me go to first to Brad and then again to Rich to talk about the mortgage area.
I mean, I think if you're a financial institution and you take your foot off the gas on monitoring for disparate impact, on making sure that your policies and practices and statements by your organization don't discourage people, you're asking for a lawsuit. You're asking for potentially future regulatory action. You're asking for a bad Community Reinvestment Act rating, and you might to boot get private case brought against you or a state case brought against you. So taking your foot off the gas on compliance doesn't make any sense to me at all, even in the climate we're in now.
Yeah. I assume you're going to agree with that, Rich, right?
Yes. The fair lending and in other areas of lending, what a lot from the mortgage industry is you're hearing, and I'll use this a lot, is stay the course, that we'll have a different administration at some point. There will be another CFPB director. We don't know what that'll look like, but it won't be the current acting director. And there's a lot of statutes, particularly under theories that toll statute of limitations, there's long look back periods. So, and it doesn't make sense to dismantle a compliance program and then try to rebuild it back up later on, particularly if a new regulator comes in and sees that you dismantled your program and built it back up, you're immediately a target. So stay the course.
Yeah. So, John, just to put an exclamation mark on what Brad and Rich have said, are there concerns that that various states won't recognize what the CFPB has said here regarding what constitutes unlawful?
Yeah, I think there are definite concerns that states won't necessarily agree with the CFPB's interpretation of the Equal Credit Opportunity Act, and other states are simply going to proceed under state laws. We know there have been a number of states that have brought actions that are premised in part on branch location. There have been, I think, New York, Massachusetts, North Carolina. There are just a number of states that have looked at the locations of branches and the marketing that institutions have done. If you're going to be aggressive on the federal side, you're certainly going to have to be very mindful of the states in which you're doing business to make sure that you aren't exposing your institution to exactly the risk that you've got in the prior federal administrations.
Okay. Let's turn now to the third major thing that was effectuated here regarding special purpose credit programs. I'm going to go to you first, Brad. The rule revises the framework for special purpose credit programs offered by for-profit entities. Can for-profit entities work with the guidance in the revised rule to still provide special purpose credit programs?
They can, but it's a bit harder to do now, and you have to navigate this very carefully. Under the guidance on special purpose credit programs under the Trump administration, there's specific language that you cannot meet the social needs of the community, which is in the language that's in ECOA that allows you to do a special purpose credit program, which is basically allowing you to put your finger on the scale as a lender and make some exceptions and lend more to certain communities because they've been underserved under either your existing underwriting criteria or there's been some other limitation. And so the Bureau kind of yanked that rug out from under lenders and said, you can't do these programs if you're a for-profit lender if you identify the social needs by race, color, national origin, or sex, or any combination of those characteristics. Now, interestingly, the Bureau did say, well, you can do maybe you can do plans based on religion, marital status, age, or the type of income that you're getting. So it's really muddied the water. So I think what you're going to see is there's still going to be lenders who are doing very successful down payment assistance programs. They may not call it a special purpose credit program, but it's good for business for them to offer down payment assistance. And they'll do it in a way that's like to first-time home buyers, first-generation home buyers, and they'll target and some areas that even the Bureau in its rule said were okay. were majority minority census tracts and low and moderate income geographies. So you can still do special benefits or incentives or loosen your underwriting standards for those communities, for majority minority census tract communities or low and moderate income communities under this new rule. So you'll find language changing in the plans of existing plans will be modified to come under this rubric. It's just going to require, to be honest, some lawyering and some advice to make sure that you're doing this in a way that's not going to put a target on your back with the Trump administration.
So, Rich, final question I have on special purpose credit programs. Do you expect that for-profit institutions are going to scale back or even eliminate these kinds of programs as a result of the revisions?
I think very much so, particularly the less risk-adverse entities such as banks this will be an issue for them. This is particularly a concern in the mortgage industry where, with home prices the way that they are and income not keeping up with them, very difficult for people who are first-time home buyers to come up with the down payment and closing costs needed to purchase a home. And a lot of special purpose programs have been designed to meet those needs by providing down payment and closing cost assistance. So it'll be a shame if we lose some of those programs. Now, you may see some entities, particularly some who have a little more risk tolerance, trying to alter or remove specific race or ethnicity-based factors for other factors. But the issue there will be how aggressive will the Trump administration be in assessing whether down payment assistance or similar programs are using proxies for race and other prohibited bases. So I think we don't have the full picture here yet of what the full extent of the risk will be.
Yeah. So compliance and risk management, all of you have agreed that you stay the course. But for creditors that are listening today, are there things that they should be doing right now in response to the final rule? For example, there are policies that many banks have and maybe non-banks that refer to the old version of Reg B. Should there be any changes? Do you leave things as is? What are you recommending? So let's go to Brad, and then Rich, I'd like to get your view from a mortgage perspective.
Basically, the Trump administration has given creditors 3 more years to kind of get their ducks in a row. You're not going to be at risk of getting a foot fault by a federal regulator on a statistical difference. So it's a time where you can really take stock on your compliance management system and keep your foot on the gas. And if you have a special purpose credit program that's geared towards race or ethnicity or gender or one of the areas that's in the final rule, you need to change that, and you need to look to language that's acceptable to the Bureau. But to the extent that you are looking at your lending patterns and you're seeing differences in the communities that you serve based upon race, color, ethnicity, any of the protected classes, you have 3 years to get it right. And so it's kind of a free pass for 3 years, but it's not endless. And so I would spend the next 3 years, if I was a lender, getting my ducks in a row and triaging my resources to look at models that I'm using, and know that for the next 3 years, you're not going to get sued by the federal government unless you're making a blatant mistake.
Right. Rich?
Again, the mortgage industry is different in that we have the Fair Housing Act, and as noted before, there's similar state laws. A lot of states have their what often referred to mini ECOAs and mini Fair Housing Acts. So I think for mortgage lenders right now, it's keep doing what they've been doing if what they've been doing is producing good results from a fair lending standpoint.
I would just add that I think it's a good practice at this point to really do a survey and get a good handle on what the state laws are that now apply to your institution. It's kind of been an assumption that as long as you're doing things that are not going to be objectionable at the federal level, you don't really need to worry about the states. Now that what's objectionable at the federal level is going to change significantly, though I guess we'll have to see where the dust settles when the litigation is over.
John, I agree with what you just said. It's important to know what's out there. But there'll be a lot of states where there won't be anything, there won't be a regulation, there won't be any guidance, there won't be anything. But they're what I call the Democratic trifecta states. And I think at last count, there were 15 of them, where there was a Democrat governor in both houses, the House and the Senate at the state level are controlled by Democrats. And, where do you put them? I would consider them, most of them, to be very risky and, a lot different than a situation that's not a Democrat trifecta.
Well, some of those states that are trifecta states already have fairly aggressive statutes and regulations or a history of anti-redlining enforcement. But I think the safest approach, and certainly what we'd recommend, would be to just watch what's going on at the state level.
Right. So we probably have already answered this, but I think it bears, again, putting an exclamation point on it. How should institutions be thinking about fair lending risk in a world where federal ECOA enforcement is narrower, but state regulators may continue to apply disparate impact? There's a risk of private litigation. There are a lot of people out there at the state level that don't like what's happened here. We're going to talk in a minute or so about the possibility that this rule is going to be challenged. That's another thing. Don't know what the courts are going to do. So, John, we go to you first, and then Rich. What should institutions, how should they be thinking?
I think we've answered this. The best course, the best approach is to stay the course. And as Brad said, this is a good opportunity to get a handle on what's actually going on at your institution.
And I think Brad said for 3 years. I think it's maybe a little closer to 2.5 years, where it's so you don't have that much time. Let's talk about. Let me go to you, Rich, on the mortgage.
Again, with the Fair Housing Act, that makes the analysis very different in the mortgage area, where that we still have clear disparate impact liability under the Supreme Court case.
Yeah, I'm going to turn now to algorithmic lending, AI algorithmic lending. One of the biggest concerns that are raised by critics is the impact on AI and automated underwriting, automated underwriting. Without disparate impact, is there a risk that algorithmic bias becomes a lot harder to detect, or do existing controls sufficiently address that? So, and then are there state laws that may come into play here? I'm going to go to you first, John, and then again go to Rich.
Well, maybe harder to detect in the sense that we may not have federal regulators going in and scrutinizing model building in the way we have in the past, looking for evidence of disparate impact. But I think the risk is likely still there. We've discussed what's happening with disparate impact and whether it's going to go away or just maybe be off the table for a short period of time. State level actions, this is really a weird area right now. We have states that have taken actions against what they perceive as disparate impact with algorithmic underwriting, as Brad mentioned, Massachusetts and the Earnest settlement. The new New Jersey regulation that we talked about specifically mentions of, just not having discrimination as a result of this kind of underwriting. And then there's a Colorado law that we've talked about, not in this context so much, but in some of the presentations out of our privacy and data security group, that prohibits discrimination. But overlaying the state law developments is the Trump administration's efforts to preempt all state laws in this field through executive orders and directions to agencies to pursue preemption. And In fact, there was an announcement, I think maybe last week or within the last 2 weeks, by the Department of Justice that it was seeking permission to intervene in a lawsuit against Colorado, challenging its anti-discrimination and algorithms law. So, there may not be much at the state level right now, but it's still, like the other practices we've discussed, it's still prudent to have a good idea about what you're doing and manage that process carefully right now.
And I would add at the state level, and at the federal level, how do you prove a model or an algorithm intentionally was trying to discriminate? It's a hard case to make. So I think states are going to still rely on disparate impact. They're going to say the models, because of the way they were trained and the data that went into them, were leading to different effects.
You're going to make an intentional case. You're going to have really odd instructions to the model builders, I think, in terms of what data to include and what weights to give to certain variables in the model.
Yeah, like no one's going to say make sure to exclude historically black colleges graduates or where you shop kinds of things. But there will be data and training that's done on these models that leads to very different impacts in different communities, and that's much easier to enforce.
Yes. Again, it's kind of two different factors pulling in two different directions. One, because of the Fair Housing Act, clearly these AI systems can be analyzed for disparate impact. But in terms of automated underwriting, which is heavily used in the mortgage industry, there's a practical factor that, frankly, and again, practical helps mitigate the risk. The predominant automated underwriting systems in the mortgage industry are those of Fannie Mae, Freddie Mac, and FHA, the government. So that creates a hurdle to someone seeking to successfully claim that the systems result in a disparate impact or even disparate treatment. So, how long that protection lasts remains to be seen, but so far that has been viewed as giving you some comfort if you rely on those systems that you have some level of protection.
Right. So let's get to, I'm going to turn to you, Brad, because I think you're more tuned into this than the rest of us. Do you expect to see legal challenges to the rule? And I guess if so, what are we talking about from a timing perspective? This is something that's going to happen pretty quickly. And what will the challenges look like? And what are the theories that can be used to attack this final rule?
Yes, I'm already aware of some state and private litigation that's being focused on right now. And I think Rich was correct that probably you'll see lawsuits filed a little bit closer to the date that the rule goes into effect and is applied, closer to July. So law firms will be taking their time to get their cases ready and pulling together potential plaintiffs from a variety of sectors, not only the advocacy community, but businesses that are impacted by the failure, for instance, to enforce the disparate impact rule. And so I think that the cases are going to be brought on a couple of grounds. One will be to look at, for instance, on disparate impact, that there is language in not only the statute on the basis of race, et cetera, that allows for a disparate impact claim, but also the congressional intent that's clear in the legislative history that was completely disregarded by the Bureau. So that'll be one grounds, that the intent of Congress has been disregarded. And so that would be a constitutional grounds, but there'll also be an Administrative Procedures Act challenge, because this was really crammed through very quickly. The Bureau just very off the cuff just disavowed and really didn't take into consideration some of the arguments that were made and substantial comments by the advocacy community. And so I think it'll be challenged on substantive grounds and also on the congressional intent, separation of powers, constitutional grounds, but also on the APA grounds as well.
Yeah, and then, of course, you've got the Supreme Court opinion in Loper Bright Enterprises that essentially eliminates the Chevron deference doctrine. That works in favor of the challengers, I would think. And so I guess, among other things, if you were ever thinking of running roughshod over fair lending, there's at least it's more than a possibility, probably a significant possibility that this rule could get thrown out.
Right. Ironically, institutions that wanted Chevron deference eliminated are now going to get burned on this case because the courts, you're right, can say, we need to look to the legislative intent here. We don't need to follow what the Bureau's decided because of Loper Bright.
Right. They will apply, I guess, what's the lesser standard of Skidmore deference, where it's really not much deference at all. They'll look at what was done. They'll examine the thoroughness of the work that was done by the Bureau. I think we're talking about a period of about 5 months. Am I right? From the end of the comment period until when the final rule came out. I'm wondering how that compares to other instances of rules that were promulgated in the past by the CFPB. 5 months, sort of an average time, too short. It's certainly not long, I don't think, but I just can't compare it.
Yeah, I expect legal challenges on both what APA grounds and substantive grounds. 30-day comment period, 5 months, narrower rule, so 5 months isn't completely shocking. But when you have 65,000 comments, they say, well, a lot of them were single, few sentences. Well, you still have to look at them, and that's a lot of things to look at. And an interesting factor here with the Bureau is, this rule had to go under review by Office of Management and Budget. The director of the Office of Management and Budget is Russell Vogt. The acting director of the Bureau is Russell Vogt. So what review did it really get? That may become a factor in any litigation challenging Bureau rules. And also, you're right, when we did as Ballard did a presentation on Loper Bright, we say, be careful what you wish for, you may get it. When an agency you don't like what an agency did, then Loper Bright is great. But when you like what an agency did, then Loper Bright is not so great. So it works. It actually works both ways, and we may see that come into play here. If I had to rate it, I think probably the special purpose credit program provisions are the most likely to be struck down because it just does not seem to be consistent with the ECOA provisions. Disparate impact, although it's not an ECOA, I think a lot of courts will look at prior lower court opinions and may rely on those. I think it'll be a different matter if it gets to the Supreme Court. The discouragement, I think the Bureau has a little more leeway there, and so those may survive with some revision, but will remain to be seen. My guess is one or more of these provisions will have a preliminary injunction granted blocking them, and so we'll have to wait to see for the ruling on the merits.
Yeah. And of course, that won't be the end of the matter. It'll go up to a court of appeals and could very well go up to the Supreme Court. And
I think that's the goal on disparate impact of the Trump administration. The Supreme Court has never addressed whether you can bring a disparate impact claim under ECOA, and I think they want this court as currently constructed to address that.
I'm kind of curious as to whether we're going to see the CFPB say that they ran the comments through a artificial intelligence model and determined there were really only 5 that they actually needed to read that were, some finite, more manageable number to try to whittle that 65,000 down.
It could have been even more treacherous for the viability of this rule. Originally, there was a conventional wisdom at one time when the CFPB looked like it was going to be running out of money, that they wouldn't have the staffing to get this thing, to go much further than January or February. They were talking about issuing an interim final rule. Fortunately, that's not the way they ended. They ended up being able to get the funding, much to their dismay, I'm sure, but they did get the funding. And there was no interim final rule. That would have been even more treacherous, I think.
Yeah, I think with the short comment period and then the 5 months, putting aside that tens of thousands of comments were simple 1 or 2 sentence comments from consumers, I looked at various comments by consumer groups and industry trade associations that usually have very robust comments, and they were not as robust as typical, and I think that was because of the 30-day comment period.
So looking ahead, how durable is this framework? Could a future administration reverse course again, appeal this rule and reinstall the old rule? John?
Well, certainly that's a possibility. I think the two parts that are especially vulnerable are the discouragement and the special purpose credit program, because they're keyed to the exercise of the Bureau's rulemaking authority that's specifically laid out in the statute. And, a new director or new administration that disagrees with the premises that led to those conclusions, I think could look at the history, re-examine it, look at what's happened in whatever interim period we have, and say that, in fact, that the need that originally existed for these provisions still exists. Disparate impact, I think we're probably going to have to see what happens in the courts, or how quickly a case moves up to the Supreme Court. It's certainly possible that if it doesn't get up within 3 years or whatever period we have, that a new administration could yank the rule on the eve of any review by the Supreme Court and try to.
Well, I think they'd have to, wouldn't they have to, John, propose to yank the rule and put that through a comment?
I think they could propose to extend the effective date while they reconsider and see what they might do. I mean, these are all.
What's good for the goose is good for the gander, right?
Yeah. But I do think the timing with disparate impact in the courts is probably going to drive the result, and it may end up tying the hands of any future administration and future CFPB.
The last thing we were going to talk about, we covered most of this already, but I'm going to make this a very simple question. Industry perspective, after this change came down, were any of you inundated with calls from clients who wanted to go out and celebrate and go to pop the cork on the champagne?
No, nobody called saying they were running out into the street to burn their CMS manual.
Right.
So I think there's a lot of concern about what this means and what exams might look like, and then the whole panoply of issues we've been discussing about.
And I've certainly seen, Alan, it's a little bit like, I think with the industry, it's a little bit like the dog that caught the car. It's like, oh my God, we actually got this relief. But now it's very muddied and we're trying to figure out what to do. And do we continue? So it's caused confusion in the industry.
Yeah, I agree with that. Okay, well, let me thank all of you for the remarks that you made today, and the really a lot of thought that you've put into what appeared to be something that was really going to change things dramatically. And I think my conclusion, my feeling is while it represents a fundamental recalibration of fair lending enforcement, at the federal level by the CFPB, it really doesn't amount to much more than that. And while the change provides greater clarity and predictability for financial institutions, at least insofar as how the CFPB views fair lending, there still is a lot of risk. There's a shift to the state regulators. There'll be private litigation. We don't know what's going to happen to this rule once it gets challenged. And we have future regimes. As everybody has said, vote won't be there forever. And there will be other administrations and things will change. So, and also I think, one of the things that is really important to think about is the connection between what the CFPB has done here and the use of AI and algorithmic underwriting. The message is clear here, although the rules appear to have been changed, is really nothing major that ought to be done by any of the institutions as a result of the changes. Stay the course. Brad, John, Rich, thank you again for participating today. And I really want to thank all our listeners who took the time to log in and listen to us. I'm sure we haven't heard the final word on any of these topics. We'll be seeing what the courts are going to do, and I'm sure we'll do a future podcast on what's happening in this area. So I hope everybody enjoys the remainder of their day.